Hey, Elder Legal Warriors. In this video, I'm going to cover the law in Washington State known as deferred prosecution. Deferred prosecution is a law that lets defendants get certain types of cases dismissed if they do a certain amount of treatment. And that sounds pretty good, but there's a lot of catches, a lot of safeguards, and it's not for everybody. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. So if you find this video useful, please like and please subscribe. More people will get to see it. I'm just putting these out to educate the public. So let's just jump right into it. Deferred prosecution. What is it? Well, on a broad level, deferred prosecution lets somebody charged with a non-felony assert to the court that the crime is caused by alcohol abuse, drug abuse, mental health problems, things like that. And it lets that accused person do a certain amount of treatment and stay out of trouble for a certain period of time to earn a dismissal in their case. What's a dismissal mean? No jail time, right? No fines, maybe only court costs. Avoids any criminal suspensions, that type of stuff, or driving type offenses. So it sounds like a pretty good deal. And what can we do a deferred prosecution on? Gross misdemeanors and simple misdemeanors, again, non-felonies that are caused by alcohol abuse, drug abuse, mental health issues. But it's a lot more specific than that. And so if you are considering, hey, how can I do classes to get my case dismissed? The law you need to look at is RCW 10.05. So you can type that into your browser, or we're going to link to it in the description below. But basically, it describes what we have to do for a deferred prosecution. And I'm going to limit the subject of this video for deferred prosecution for DUIs, driving under the influence type charges, because that's where it's most commonly used. It can be used for domestic violence charges. There's different rules and different restrictions. It can be used for other types of cases, but generally speaking, we only want to use deferred prosecution for a DUI if it's a traffic type offense, because we can only use deferred prosecution once in a lifetime. We want to save it until we need it. So what do we have to do to qualify for deferred prosecution? Well, one, we have to be charged with DUI in this case. Two, we have to go to an alcohol and drug evaluator who has to make a determination of whether or not we have a serious enough alcohol or drug problem to warrant qualifying for the deferred prosecution program. Three, we have to do the required treatment that gets ordered by the treatment agency and enforced by the court. And four, we're going to have to stay out of trouble for a period of time, no new crimes. And for a DUI, we're going to have no new crimes for 5 years. Okay. Of course, we also can't consume alcohol or drugs for 5 years. We have to complete the treatment program as well. And then we'll also need to pay a court cost, typically, for the court to monitor the agreement. So that's a whole lot of stuff we have to do. How much treatment is required? Well, for a DUI type evaluation, what most of us defense attorneys will tell you is what you should expect the evaluator to recommend to qualify you for the deferred prosecution program is a 2-year drug and alcohol treatment program. What does that mean? That means doing group classes and individual classes for a period of 2 years. It also means doing 2 self-help meetings a week for a minimum of 2 years on top of the group and individual classes. What do I mean by self-help? AA meetings, Alcoholics Anonymous, NA, Narcotics Anonymous, whatever applies to the situation where you're getting the deferred prosecution. So how does it physically work? Well, you get charged with a DUI, you go to the arraignment, you plead not guilty, and then somewhere along the line, you talk to your attorney and you work with your attorney to try to make a determination. Is deferred prosecution a good option for me in my case or not? And why might it not be a good option? Well, the first and most important reason is for a DUI, you can only do 1 deferred prosecution in a lifetime. So how serious are the penalties you're looking at? If it's a first offense DUI, most of the time we would tell our clients we don't want to even consider a deferred prosecution because a minimum penalty is either 1 or 2 days for a first offense DUI, 1 or 2 days in jail. We want to save that deferred prosecution, typically speaking, for a second or third offense. God forbid that happens, but the penalties are so much worse there. It could be 30 days in jail minimum, 45 days in jail minimum, long periods of home detention on top of that, longer license suspensions, bigger fines. We want to save that deferred prosecution to get out of the case for a time when we might actually need it. There's nothing that annoys us more at my office than we have someone come in with a second offense DUI and some lazy attorney, in my opinion, put a client on a deferred prosecution on a first offense. Again, there may be a good reason to do that. There may be such a big alcohol and drug problem that the client needs that carrot to get the dismissal, to do all the treatment they need to do. There may be an immigration reason where if we get put in jail for any amount of time, we're worried about getting deported. There can be reasons, but in general, the philosophy of my office is it's a really bad idea to even consider a deferred prosecution on a first offense DUI unless there's very specific and unique circumstances where the benefits outweigh what we're giving up by not saving it for later. So one reason why we might not want to do it is we only get to do it once, and the penalties may not be severe enough to justify using it on a first offense. What's another reason we may not want to do it? Well, it's a lot of work, right? A 2-year treatment program typically consists of 3 group sessions a week for 2 months. Those are multiple hour sessions, followed by 1 group session a week for 6 months, followed by 1 group session a month for 16 months. There's individual sessions thrown in, and that entire 2-year period, you're also doing 2 AA meetings a week at a minimum. You might be required to do more. So think about that. During the first month, the first 2 months actually, you're probably involved in some type of treatment 5 days a week, and that could be hard, right? It could be hard if you have children to raise, if you have a work schedule to keep. If you're traveling, it may be impossible to do depending on what your profession is and what agency you use. You may also run into an agency where they're not going to allow you to use medical marijuana or do other things that you feel are consistent with your health, and they may not allow that. So it may be hard to do the treatment. That'd be the second reason you don't want to do a deferred prosecution. What's a third reason? Third reason you may not want to do a deferred prosecution is that you may have a legal defense, right? Our office is typically going to exhaust legal defenses and try to look into the case first before we consider using that once-in-a-lifetime deferred prosecution and having the client put in all that work. Now, there's going to be benefit, right? If we get through the program, we're probably not going to have a better support to not drink and use drugs and have it affect our life anymore. But from a legal perspective, still, we want to save that one time we can do it. So if we have a legal defense, maybe we want to assert that and not use a deferred prosecution. I'd say the fourth reason could be the cost, right? A typical deferred prosecution program might cost $5,000, $6,000, $7,000. Now, if you have for the treatment costs alone, court costs might be $2,500, right? So if you have health insurance, it may cover some or all of the treatment, but a lot of people don't have that health insurance. And so cost can also be a factor. So those are some reasons not to use the deferred prosecution. Why might we want to use the deferred prosecution? Well, we already talked about it, right? If we successfully complete the deferred prosecution, we get our entire case dismissed. And if we had 3 charges, let's say we had drive-in on a suspended, no interlock, and a DUI, they all happened at the same time, the one deferred prosecution gets all 3 charges dismissed. That's a pretty big deal, right? Making 3 charges go away. It can also beat any criminal court suspension, right? So there's 2 suspensions in a licensing hearing if we blow over the limit or we refuse. There's the administrative hearing where Department of Licensing takes action to suspend our license regardless of what happens in court. And there's a court potential suspension if we're convicted of a DUI or some reductions from DUI. Now, the caveat here is while a deferred prosecution does beat all court suspensions, it only beats some administrative suspensions. The legislature, in my opinion, made a mistake. I remember 15 years ago, I had all the statutes laid out on my desk trying to learn as a younger defense attorney, how all these statutes work together. And I could see where the laws got passed. Basically, the legislature has the laws written in a way where if we do a deferred prosecution, it overrides any administrative suspension if you took the breath test or blood draw, but it does not override the administrative suspension if you refuse the breath test at the station or a blood draw. And so you still got to fight that licensing hearing, especially on a refusal, because the deferred will beat the criminal suspension, but it won't beat the administrative suspension on a refusal. I see no evidence in the statute that that's purposeful. It looks like it's an oversight. So if you're watching this legislature, I don't see why we punish people additionally if they refuse than if they don't when we offer them an opportunity once in a lifetime to better themselves and do treatment in lieu of prosecution. I don't see why that is, but please be aware it is. And your attorney should be able to tell you that. The other good news is if you're planning to do a deferred prosecution and you suffer an administrative suspension on a non-refusal, your attorney can send in a notice to the Department of Licensing to put off your administrative suspension for up to 150 days to give you time to get the deferred prosecution entered. And that can keep you driving, right? And we need to keep driving often to get to work, to get our kids to school. For many different reasons, we need to keep driving. So what's the reason to do the deferred prosecution? It makes the case go away, makes it you get a dismissal, and it can also beat the license suspensions. And when we say we make a case go away, think about that. It also keeps a criminal conviction off of your record, right? Because if you're not convicted, you don't have anything in your state patrol record. There's still going to be a record of it on your driver's license and your licensing records, but it's different than a criminal conviction because you're not convicted. If you're a non-citizen, you need to talk to an immigration attorney because there can be a line of thinking that if you're found to be drug and alcohol dependent, that could potentially cause some issues for your immigration case. I'm not an immigration attorney. It's very unique, but I'm just suggesting that if you're a non-citizen, definitely run everything by an immigration attorney in addition to your criminal attorney because those are separate levels of knowledge that each attorney needs to maintain. So what are some caveats? I promise you some cautions in there. Well, one of the cautions is you have to really be careful about what can get your deferred prosecution revoked, right? The law says that if you have a similar offense you're convicted of, the court shall revoke your deferred prosecution. So if you have a DUI and you get another DUI, well, they have to revoke your DUI. But think about this. If you have a DUI and a suspended license charge on a deferred prosecution and you get another suspended license charge, there's a good argument that the prosecutor can make that that suspended license charge is a similar charge to what's on the deferred, the other suspended license charge, and now your DP, your deferred prosecution, shall be revoked. So there's a difference of opinion in my office about what we should do, but it is definitely a cautionary tale about what we put on a deferred. Additionally, we have to be careful about what we eat or drink because, for the 2 years of treatment, you're going to be undergoing random UAs, your analysis test. And if it comes back positive, the court has the ability to revoke you. And it's going to make you go back into court. You may get your deferred revoked. And then bad things are going to happen. Additionally, if you're not careful, you may have an interlock, right? Part of a deferred prosecution will require you to put an interlock in your vehicle for 1 year or 5 years. It varies based upon what your prior record is. But when you blow into that interlock, sometimes those things aren't that accurate. It may show a positive when you're not drinking that's going to pull you into court. You use mouthwash. There's certain things that have alcohol in it, even though you're not consuming the alcohol. The machine doesn't understand it, right? It only tests what's in your breath, not what's in your blood. And so you have to be really careful so you don't get an accidental positive and get your deferred prosecution revoked, even though you weren't drinking, okay? And there's been some fights that I've had to the death almost in certain cases. Luckily, they've usually come out in our favor, but I'd rather that nobody be in that position. So what does it mean if we get a deferred prosecution revoked? You're using all these words, Lance. Well, it basically means you get convicted, right? The court says, well, when you sign away your rights for deferred prosecution, you agree you're guilty of the crime, and you agree that if you mess up, that the court's going to read the report and find you guilty of the crime. And then what happens? You get sentenced, right? And if it's a second offense, it might be a pretty big sentence. A third offense is going to be a really big sentence. You're going to get sent to jail. You're going to get suspended again, and you're still going to have to do all the treatment. And so, you no longer get any benefit, and you still have to do all the treatment after the fact. So it's really important that if you enter a deferred prosecution, you take it so very seriously. There's nothing that's sadder, not much in the criminal system when it comes to non-felony cases, than a revoked deferred prosecution, because the consequences are great. We don't want to have it revoked. So one more caveat. You can't just go and do a deferred because you feel like it. You have to get an alcohol evaluation from a state-certified alcohol and drug treatment provider, and they have to make certain findings. The findings are in the statute, 10.05, but the way to tell it for a lay person is they have to make a determination that, one, you have an alcohol or drug problem that requires treatment, that if you don't get the treatment, the probability of reoccurrence is great, and that also that you're amenable to treatment, which means, you're willing to do it, and also it's likely to be successful. And the minimum they're going to be able to recommend for a DUI-based, alcohol-based type deferred prosecution is that 2-year treatment program. So you had to get the evaluation that recommends it. So let's say you're not sure you want to do a deferred prosecution. Maybe you don't want to go get that alcohol evaluation right away, because if you come back with an evaluation that recommends 6 months of treatment, you're not eligible for deferred prosecution because you don't have a big enough problem that you qualify under the statute. Okay? You might be able to get reevaluated, but things get hairy at that point. So again, different attorneys' opinions will vary about how they do it. But for my personal clients, I'll typically wait to get an evaluation unless it's an emergency situation where we need to get into treatment because we simply just cannot stop drinking. We can't stop the problem without the treatment that a person may need. That's one of the caveats about when you do the eval matters, because if it recommends something else, you may eliminate your ability to do a deferred, and that's really not what we're looking for. So once in a lifetime, 2 years of treatment, 5 years of lawful behavior, reward, dismissal. We mess it up, punishment, conviction, sentencing, and we still have to do all the treatment, okay? And they get a whole new 5 years of jurisdiction after they sentence you. You could, if you were 4.5 years in the deferred prosecution, you get it revoked, they're going to sentence you and take another 5 years of jurisdiction. This case has went on for 9.5 years, okay? So if we're going to go into it, we don't want to actually sign away our rights and enter the program until we've had, in my opinion, several months of compliant treatment, so we know we're set up for success. If you mess up before entering the deferred prosecution and you drink, there could be a consequence with the court, but it's not going to be a revocation of your deferred prosecution that you haven't entered into yet. So it's a great solution for a lot of people. It's a got you and a trap for a lot of people. And it's also a trap for people charged with a first offense where an attorney just doesn't want to work and says, here's a magic way out, and you go, great. And they don't go over the rest of the reasons why you might not want to do it. So I hope you found this video useful. If so, please like and please subscribe. More people will get to see it. More importantly, if you've got a criminal problem in Washington State, feel free to give my office a call. We've been doing this for more than 20 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.